In this video, we're going to give an overview of copyright law. We're filming this video from TechArb, the student startup incubator on the campus of the University of Michigan. As you can imagine, many student startups involve software. And one form of intellectual property protection to consider whenever you have a software-enabled invention is copyright protection. So let's give a very general overview of what that means. Copyright can be used to protect characters, graphics, stories, music, movies, or source code. Copyright protection is much easier to get than patent protection. In fact, copyright protection is automatic as soon as any expression has even a low amount of originality and as soon as it's reduced to writing. So as soon as an entrepreneur writes some source code, copyright automatically protects that source code. Now, you can add a copyright notice. You can also register your copyright at the United States Copyright Office. And those steps give you additional procedural benefits, such as the ability to sue in federal court, the ability to collect certain damages. But copyright protection exists as soon as you reduce something to writing, and in the context of software, as soon as you write some source code. So the owner of a copyright has the exclusive right to reproduce the copyrighted work, to distribute the copyrighted work, to modify the copyrighted work, which we call creating a derivative work, to publicly perform or publicly produce that the copyrighted work. But it does not protect against independent creation of that copyrighted work. So unlike patent law, where if one has a patent, it prevents anyone else in the country from making, using, selling, offering to sell that patent technology, even if they don't know about the patentee's technology or the patentee's patent. With copyright, you only have the right to prevent someone else from using something substantially similar to your copyrighted work if they've actually had access to your copyrighted work. Basically, if they directly make a copy of it. So theoretically, you could write some source code behind a new mobile application. Someone else could be entirely unaware and could write that exactly same source code, and they would not be infringing your copyright. It does not prevent independent creation. In that way, copyright protection is an extremely narrow form of protection. Another example to show how copyright is a relatively narrow form of protection is in the context of data. Copyright does not protect data or a database unless that data is organized in some original way. And even in that case, copyright only covers the organization, the ordering of that data. This issue was addressed by the Supreme Court in a case involving the white pages of a phone book. Someone spent a bunch of time tracking down all the names, all the phone numbers, and putting them in alphabetical order in a phone book. Someone else basically made an exact copy of the white pages from that phone book and started competing against that company. Now, the original party that created the white pages sued the other party for copyright infringement, saying, you know, we spent so much time collecting this information and organizing it, they shouldn't be able to copy that. But the Supreme Court said that there was nothing unique about alphabetical organization of these names and phone numbers, and that copyright didn't cover the data, the facts, and basically anyone else was free to use that data or facts. Copyright law did not cover it. So this comes up a lot in the context of databases. It's important to know that copyright probably doesn't cover the underlying data in your database, and you need to find some other way of protecting that data, either trade secret protection. If you're going to keep that data secret, if you're going to share it with other people, then you need to use contracts to protect that database. And that is a general overview of copyright protection.